of the company. In this case, it basically means that this person will actually be able to come in and actually be able to manage all the affairs of the company. So some of the reasons that can actually basically lead to a receiver actually being appointed, then of course this one can actually basically be gotten or actually be understood better when you actually understand who can actually actually appoint a receiver. So this receiver can actually be appointed in a company by the creditors of the company, or basically can actually be appointed by the court or a mandated. We can talk about a mandated body, actually being able to appoint a receiver. So for example, when you looked at the topic of debt capital, then you actually understood that in a company, we have persons known as debenture holders. So these particular persons, debenture holders, are actually creditors of the company. So if the company is not actually able to meet the obligations in terms of actually being able to pay the debenture holders or the creditors of the company, then of course they can actually be able to appoint, or they have a right. You actually told some of the rights of debenture holders in a company is actually to appoint a receiver. So these particular creditors or basically debenture holders will actually basically appoint a receiver to take over take over the assets that have actually been used as a security. So they'll actually only be able to appoint a receiver in case the company is not actually able to meet their obligations in terms of actually the interest the creditors have in the company. For example, in this case, the debenture holder is actually expecting to get principal and the interest from the company. So if the company is not actually able to meet this particular obligation, then it means that the creditors, who are actually the debenture holders, they have a right to appoint a receiver. So when you talk about a receivership, is that particular, is when actually a receiver, a person known as a receiver, is actually appointed to take over the operations of part of the operations of the company, or basically manage all the affairs of the company. It basically means that he's actually taking over the mandate of the management of the company. So it means that if a receiver is actually appointed, then it means that the persons in this case who are known as, like, for example, the directors, they actually basically lose their position. So the company will actually be taken over by the receiver to manage all the affairs of the company for the interests of the creditors of the company. In this case, it means that if the company is not actually able to meet its obligations, then this particular receiver can actually be able to come in, manage the company. Maybe it was actually basically not being managed properly. So some of the interests of the creditors in the company can actually be safeguarded by the receiver. So in most cases, a receiver appointed by the creditors will act for the interest of those particular specific creditors. Then we can actually have the courts actually appointing also a receiver. So a receiver appointed by the court will act for all the interests, for the interest of all the creditors, for the interest of all the creditors. So mostly a receiver appointed by the court will act for the interest of all the creditors. A receiver appointed by the creditors or a specific creditor in the company will act for the interest of that particular creditor. So it means that, for example, if you actually are a creditor in a company, you used the asset of the company or charge the asset of the company, like the motor vehicle, then it means that when you actually appoint a receiver in the company, this receiver will specifically come for the motor vehicle, maybe dispose it off or sell off the asset so that you can actually be able to recover your money from the company. So the receiver will come in basically to manage either part of the assets of the company or manage all the affairs of the company. So in this case, it means that he'll actually take over the control of the affairs of the company. So when the company is actually under receivership, it will actually still operate. It is important the company continues to, for example, operate. Let's say, for example, if it was making losses, if a receiver will come and then he can actually basically manage it appropriately, the company will come back to track and actually be able to make profit for the interest of the creditors. So it means that this company was not actually able to meet its obligations because it's not maybe being profitable. So when the receiver is actually appointed, he can come in and actually basically turn things around. And later on, we'll see that if receivership does not actually work, then automatically what will actually be recommended is that the life of the company should actually come to an end. So if receivership actually works, then of course this company will basically be given back to the directors of the company, or will be given back to the management of the company they continue to manage the affairs of the company. Sometimes a receiver can actually be appointed by a mandated body that has actually been allowed under the law to be able to appoint a receiver. A good example we can actually be able to give, is for the case of, for example, banks under the Central Banks of Kenya Act. So under the CBK Act, in the case of banks, then the Central Bank of Kenya, under the CBK Act, the Central Bank of Kenya has actually been given the mandate to be able to basically appoint a receiver in the case of banks. If the banks are not actually operating according to the requirements under the Central Bank of Kenya Act, then the Central Bank of Kenya can actually be able to appoint, because it's the regulator of all the banks in Kenya, they can actually be able to appoint a receiver in the case of banks. So there are several banks recently that have actually been put under receivership. For example, the most recent one, which was actually very famous, you can remember it, it was the case of Chase Bank, I don't know if you can remember, it was around 2016. So Chase Bank was actually put under receivership after it was discovered that the directors were actually basically flouting the requirements in terms of management of banks. So to protect the interest of the customers or the stakeholders of the company, the Central Bank of Kenya actually appointed a receiver to take over the affairs of Chase Bank, So for all the banks, they normally appoint the Kenya Depositors Insurance Corporation as the receiver. So the Kenya Depositors Insurance Corporation was appointed by Central Bank of Kenya as the receiver of Chase Bank. So automatically the directors of Chase Bank actually lost their position. So the bank was actually taken over by the receivers. So this particular body, it doesn't have the expertise to be able to manage banks. So they had to appoint another party. So saying these ones were actually the receivers. So if they lack the expertise, then of course they can engage other parties known as receiver managers. So the receiver manager for Chase Bank was actually the Kenya Commercial Bank. So if the receiver does not have the expertise, then of course he can actually basically seek expertise from a person who is actually able to manage the affairs of the company, or basically run the company. So KCB was actually appointed because it has expertise in actually managing affairs of banks. It's actually a bank. So they could actually be able to manage Chase Bank appropriately because they have the expertise. So they are the receiver managers of Chase Bank. So they're actually appointed by Kenya Depositors Insurance Corporation. So that is what we mean. That's how we can actually be able to explain what is actually receivership. The most recent one, when you talk about a creditor actually being able to appoint a receiver, you must have actually heard of this one. This is the case of Kenya Commercial Bank and Mumias Sugar. Kenya Commercial Bank and Mumias Sugar. So you know Mumias Sugar, I don't know if they are out of receivership. So this particular bank actually appointed a receiver to manage the affairs of Mumias Sugar. So it means that this company was actually owing money for KCB Bank. So KCB Bank as a creditor, under the agreement maybe of lending, they had actually agreed that they have charged the assets, or they have used the assets of Mumias Sugar as security. But of course, you know what has actually been happening with Mumias Sugar. It has actually been making losses consistently, and it was actually going to go under, or actually undergo, liquidation. So these guys actually appointed a receiver to basically take over the management of the affairs of Mumias Sugar. So it means that if this receiver can actually be able to manage Mumias Sugar appropriately, then of course maybe it could actually basically come back to track and actually maybe become more profitable, such that this bank can now actually be able to recover their money from Mumias Sugar. Because if this company is making losses, it means that they won't actually be able to recover their money from the company. Even if maybe they go for the assets, maybe it is billions of money they had actually lent to them, they won't actually even realize this particular amount from the assets. So one of the things they can actually be able to do is maybe to appoint a receiver to take over the management of the affairs of Mumias Sugar, or maybe appoint a receiver to take over the assets they had actually charged in Mumias Sugar. So that's why we are saying basically parties who can actually be able to appoint a receiver in a company are actually creditors, or maybe the court, or maybe a mandated body. In that case, we are giving an example of the Central Bank of Kenya Act has actually been given the mandate, or basically Central Bank of Kenya has been given the mandate under this particular act to be able to appoint a receiver in the cases of banks, in the case of banks. So you have Chase Bank, you have, I think, Dubai Bank. It was actually also put under receivership. So if a bank is not actually operating according to the requirements of the law, then of course, CBK has been given the mandate to appoint a receiver in such a scenario. So we are saying receivership is basically that aspect of actually appointing a receiver to take over the management of parts of the assets of the company or the overall affairs of the company. Once he's actually appointed, automatically, the directors of the company lose their positions and the receiver will actually take over the operations of the company for the interest of the creditors or maybe the main stakeholders of the company. For example, in the case of banks, is for the interest of the customers. Because the reason why they actually appointed a receiver, it was realized that the directors of this particular bank and actually top managers were actually taking loans without a security. And you know what actually normally happens with banks? You actually basically deposit your money. They basically give the money out as loans. So if these loans are actually being given out without security, it means that the depositors are likely to lose their money. So after Central Bank realizing that, then of course they had to appoint a receiver to basically take over the management of the affairs of Chase Bank. So this bank was managed by this particular bank for some time. Then of course, a particular party, so Standard Bank of Mauritius, so SBM, Standard Bank of Mauritius actually came in and actually acquired Chase Bank. So it is actually still a stable bank. So they were actually able to invest in their resources, or it was actually acquired by the Standard Bank of Mauritius, the Standard Bank of Mauritius. So when this receiver actually comes in, he'll basically maybe sell of assets to realize the asset for the best interest of the creditors, or maybe manage the company to maybe become more profitable. So how is a receiver is actually appointed? We have already talked about that. For example, under the agreement of lending, if they have given the lender the mandate to be able to appoint a receiver, then of course that particular lender as a creditor will have a right to appoint a receiver. So sometimes certain creditors can actually be able to go to court, petition the court. The court will actually basically go ahead and actually appoint a receiver. So you're saying generally a receiver appointed by the court will act for the interest of all the creditors. But sometimes a receiver appointed by the creditors will only act for the interest of that particular specific creditor. So mandated bodies under any law, like for example, the Central Bank of Kenya can actually be able to appoint a receiver. So in short, that's how a receiver is actually appointed. That is how a receiver is actually appointed. So what will actually be the duties? What will actually be the duties? What will be the duties of a receiver? What will be the duties of a receiver? So this particular receiver, I've mentioned some of them in parts. He'll basically take over the custody of all the assets of the company or the company's properties and operations. So he'll take over the custody of the company's properties and operations. So there is custody of the company's properties, custody of company's properties or assets, properties and operations. So he'll take over the operations of the company and also actually secure the assets of the company for the interest of the creditors. Then another thing he'll actually be able to do is actually to pay any outstanding amounts or to pay any debts by maybe selling off the assets to realize any amount. So you can actually sell off the assets of the company to realize any amounts owed to the creditors of the company. So you can sell off the assets of the company, selling off the assets of the company and paying any debt that is actually due, the one that you can actually be able to manage. So pay as much debt as possible that the company is actually, or maybe it is government taxes. So any debt that is actually being owed by the company, he'll actually make sure that all those debts have actually been paid. So he can actually also basically, if he sees that he doesn't need any extra staffs to continue for the continuance of the operations of the company, he can lay off some of the staffs. So you've said the directors will lose their positions automatically, but of course the employees can actually be retained for the benefit of the receivership of the company. So like in the case of Chase Bank, not all employees were actually basically laid off. So some are actually left for the beneficial receivership of Chase Bank to ensure that the operations of the company are actually continuing to, or the company is actually continuing to operate. So sometimes you can lay off some of the employees or maybe retain some of the employees. So you'll have that particular power to determine how many employees are actually basically going to remain in the company and how many can actually be relieved from the company, So those will actually be some of the roles or actually duties of a receiver, So what are the advantages? What are the advantages of basically appointing a receiver? So some of them actually basically arise just out of the duties. So some of the advantages actually include is that the receiver will basically protect the assets of the company for the interest of the creditors. So that is an advantage. So it'll actually protect the assets of the company for the interest of the creditors. So a receiver appointed by KCB is basically going to protect the assets at Mumia Sugar for the interest of KCB, Then another advantage that basically arises out of appointing a receiver is that he can actually basically sell off the most viable parts of the company, or basically sell off the most viable assets of the company to be able to pay off any debts outstanding by the company. So for example, if there's the assets that were for the interest of the creditors, you can sell them for the interest of the creditors. So first of all, we are saying you can actually basically protect and actually secure these assets or basically safeguard them. The second thing, you can actually basically sell off those viable assets that can actually be sold off so that you can actually realize any amounts to be able to pay the creditors of the company, Then another advantage that can actually basically arise is basically, he basically assesses on how the company can actually be managed. So he assesses basically the company's management and actually trading activities. So you can decide which activities are actually basically going to continue as part of the business of the company, which ones are not actually going to continue as part of the business of the company. So you can actually basically assess and realize where the problem is actually in the company and what is the best strategy that the company can actually basically be put back on track. So you can actually basically assess the trading activities and basically realize which activities are actually most important for the company to continue to operate instead of actually basically going to undergo liquidation. Then disadvantages, the most dominant disadvantage of this putting a company under receivership is that if a company is put under receivership, it means that the image of the company will actually be dented. So if you hear a company was actually put under receivership, then it dents the interest of the public in basically associating with the company. For example, if you are intending to open a bank account at Chase Bank, then you hear that Chase Bank is actually under receivership, then of course you won't actually be able to go there and actually open a bank account. So putting a company under receivership basically dents the image of the company. So most people won't actually like to be associated with a company that is actually under receivership. So in such a case, maybe the company can lose its customers, its clientele, its sources of revenue as a result of an announcement that that company has actually been put under a receivership. So for example, in the case of Chase Bank, they were actually panic withdrawals. So people are actually withdrawing their money, so they don't want to be associated or actually be among the bankers with Chase Bank. So Chase Bank basically ended up actually losing some of their customers. So putting a company under receivership will basically dent the image of the company. Another disadvantage is that even if you are saying that this receiver is going to sell off some of the viable parts or assets of the company, sometimes if you put a company under receivership, then he won't actually realize the market value of these particular assets. Because what will actually happen, if people know that there is a company under receivership selling off their assets, then of course, even if they are basically coming in to put bids, then of course they'll put bids which are actually very, very low. So they won't actually basically want to acquire those assets at the market value of the assets because they know the company is actually under desperation to be able to sell off the assets, maybe to realize money to pay the creditors. So for example, even if it was actually a motor vehicle that was supposed to go for, let's say, for example, a Mercedes-Benz, 2 million, the company could actually end up just selling it at maybe 1.5 million, because anyone who will actually basically be coming for this asset will basically know that this company is desperate. So it won't actually basically bring in the market value of the assets. So some of the assets, even if they're actually sold off, when the company is under receivership, the company cannot actually be able to realize the market value of these particular assets, because the company has actually been put under receivership, because the company has actually been put under receivership. Another disadvantage that normally arises is that there's sometimes lack of expertise by some receivers to be able to manage the affairs of the company. So they'll actually be forced to appoint another person known as a receiver manager. For example, in the case of KDIC, so they don't have the expertise to be able to manage banks. So they have to engage another person. So that is another disadvantage that can actually arise. You appoint a receiver, yet he doesn't actually basically know expertise or have the expertise to be able to manage the affairs in that particular industry. So he's actually forced maybe to engage another person who has the expertise to be able to manage the affairs of the company. So sometimes there's lack of expertise on how the affairs of the company are supposed to be managed by the receivers. So that is another disadvantage that can actually arise out of putting a company under a receivership, receivership. So we are saying that if receivership does not actually work, what will actually happen is that there'll actually be a recommendation. This person appointed as a receiver, he'll basically recommend that he has tried his best. The company is not coming back to track, or maybe there's nothing they can actually be able to realize from their company. So what is actually supposed to be done is basically means that the company should actually be liquidated. So in short, what you are saying, if receivership does not actually work, automatically the life of the company will come to an end, because this receiver is being appointed to try and manage the company such that the company can actually maybe come back on track. So if the receivership for Chase Bank didn't actually work, or maybe if SBM didn't actually come in to acquire Chase Bank, it basically means that the life of Chase Bank could have actually come to an end. So it means that now they had to make arrangements on how they are going to basically refund all the depositors of the company their money. So that is usually very risky. If you actually are a depositor of a huge amount of money, you know what they'll do? They'll say, for the first year, we are going to basically give back those depositors who actually basically deposited maybe an amount up to 100,000. So like that. So a receivership of a company can actually end up basically taking, or basically liquidation can actually basically end up taking a very long period of time. So it is actually very disadvantageous, mostly if it is maybe in the case of banks and you actually are a depositor. So if you had a huge amount of money, then it means that the company can take a very long period of time before you realize the money from the bank. You'll actually eventually get your money, but of course it can actually take a very long period of time, even 10 years or maybe over 10 years. So it depends with how fast the company can actually be able to realize that amount, maybe from the sale of their assets, such that those amounts gotten from the assets can be used to pay off maybe the depositors of the company, or maybe the creditors of the company. So if receivership does not actually work, then automatically what will actually happen, the life of the company will actually come to an end, or basically the receiver will actually recommend that the life of the company should actually come to an end, So this is like putting a company in the ICU. So it's now in the ICU, it's just now on life support machine. So if things go bad, then basically means that the life of the company will come to an end. It will actually be liquidated. So that is what we actually mean by putting a company under receivership. So receivership will basically come before the company is actually liquidated. In the same case with Nakumatt. Nakumatt was actually put under receivership. It was realized that this receivership won't actually work for Nakumatt. So what the creditors did, they basically just met and actually recommended that the life of the company should actually come to an end. So Nakumatt was actually now liquidated because the receivership was not actually working for them. So the company was not actually able to be put back on track. maybe to continue to trade as Nakumat, or maybe continue to provide products to customers. In such a case, if receivership does not work, it basically means that the life of the company will come to an end. So it will actually be liquidated. It will be liquidated. So that is what we mean by receivership. So I don't know if there's a question up to that particular point. There's a question up to that particular point, because I want us to start looking at liquidation of a company. What is liquidation of a company? 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 So you have a question, you can pose a question before we can actually now start looking at liquidation of a company. So I've sent the notes there. So I don't know if you guys have actually received them. So there are notes I've sent there. Are you guys actually able to, who has gotten them? Who has gotten the notes? I've sent the notes for this particular topic. I've already sent the notes. You can download them. They are on PDF. And download them and actually use them for your personal studies. You can use them for your personal studies. So I think we can start looking at, I hope everyone has gotten those notes. Have you guys gotten the notes? The notes I've sent there. I don't know if you have gotten them. I can see Judy saying yes, she has gotten the notes. So I hope everyone has actually gotten the notes. So we can look at liquidation. We can look at liquidation. Liquidation. So what you need to know is just what is liquidation? What is liquidation? What is liquidation? Types of liquidation. Types of liquidation. this case, we look at compulsory and voluntary. Then we look at parties that can petition for compulsory liquidation, Then we look at reasons for compulsory liquidation, reasons for compulsory liquidation. Then we can look at duties and powers of a liquidator, Then we look at voluntary liquidation by members and by creditors. Voluntary liquidation by members and by creditors. Voluntary liquidation by members and by creditors So I can see Alex saying here, I resend them. So maybe let me resend the last time. So I've resent them again. So I hope you can, Alex, you can actually be able to get them. So we can look at what is actually liquidation, and see what is normally involved in liquidation. So when we start the discussion about company law, we say that a company is actually an artificial person. So an artificial person basically means that is recognized under the law as actually being a separate legal entity as a person, but it is actually created artificially by a natural person. So it basically means that before the life of the company actually comes to an end, there must actually be a process. So that process is actually undertaken, a company actually being an artificial person, there must actually be a process to basically also actually end its life. Because when it comes into formation, there's actually a process. So before it actually comes to an end, because it is actually an artificial person, it's not a natural person, then of course there must actually be a process before the life of this particular company actually comes to an end. So that process that the company actually undergoes before its life comes to an end is actually known as liquidation. So the process undertaken to basically end the life of the company, or basically for the life of the company to come to an end, is known as liquidation of a company. So of course, you are saying several things could actually be done, maybe to save the company, like receivership, or maybe the company we looked previously under corporate restructuring, the company can be involved in schemes of arrangement to basically avoid maybe liquidation. So sometimes alternatives to basically liquidating a company, it could be maybe for the company to basically undergo those particular corporate restructuring processes we looked at in the previous topic. So those are actually alternatives to winding up. Maybe merging with another company, maybe being acquired by another company like Chase Bank to avoid actually being liquidated. So sometimes in the exam, they could actually ask you, what are actually the alternatives of a company from actually being liquidated? In such a case, they basically are actually asking alternatives the company can actually basically look into before it can actually basically now say we have actually given up, let our life actually come to an end. You can just imagine if, for example, in the case of Nakumatt, maybe there was actually an acquirer who could have actually come in to basically acquire Nakumatt it means that the life of NACMAT wouldn't have actually come to an end. So all those options we looked at under corporate restructuring can actually be alternatives or actually escape routes of basically a company actually being liquidated. Like right now, you know what actually Tuskys is actually undergoing through, or they're actually going through. So they actually wrangles in management. So like there is actually what is known as deadlock in management. We'll see those are some of the reasons that can actually make the life of a company come to an end. But of course, it could maybe be due to maybe financial difficulties. So sometimes there could actually be someone, an investor, who could actually basically come in and actually inject some money into Tuskys. So that way, they would have actually gotten an alternative from actually being liquidated. An investor coming in, or actually basically another supermarket actually acquiring Tuskys, So those ones can actually be escape routes of a company from actually being liquidated. So we are basically saying that when a company is actually undergoing liquidation, it will still be viewed as actually being a person until this particular process known as liquidation has actually come to an end. So it means that even if the company is actually under liquidation, because there's several things that will actually happen during liquidation, such that, for example, all the debts of the company must actually be paid off before the life of the company comes to an end. They must ensure all creditors have actually been paid off. All, for example, government taxes that are actually due from the company have actually been paid off. So that's why there must actually be a process that must actually be undertaken by a person known as a liquidator, who will see how this particular liquidator can actually be appointed, So I can see Alex saying he has got the note, so that is actually okay. It's quite fine. So you're saying basically there'll be a liquidator. Under receivership, we've said there's a receiver who's actually involved. Under liquidation, there's a liquidator who's actually involved, a person known as a liquidator. So we'll see basically how this particular liquidator will actually be appointed by basically looking at the types of liquidation and how under each type of liquidation, a liquidator will actually be appointed. So when this company is actually undergoing liquidation, all those processes are actually being undertaken. Assets of the company have been secured by the liquidator. The liquidator is finding ways to basically list all the creditors of the company. He's finding ways on how he can actually basically sell off the assets of the company to realize amount to pay the creditors. In case there are actually any residues, he'll actually make sure he has actually basically given them to all the shareholders of the company or ordinary shareholders of the company. So while that process is actually still being undertaken, because it's not like they'll just say the company is liquidated today and everything has ended today. No, there must actually be a process. That process is the one we actually calling liquidation. So all those processes actually undertaken to end the life of a company is known as liquidation. So when the company is undergoing liquidation, all those processes, it will still be viewed under the law as actually being a person, such that any person can actually be able to still sue the company when it is actually maybe undergoing liquidation. This company, when it is actually even undergoing liquidation, it can actually basically enter into contracts, maybe contracts of maybe selling of its assets, contract of basically maybe engaging experts to enable the company maybe undergo the liquidation process appropriately. So it will still be viewed as actually being a person until this process of liquidation has actually come to an end. So when the liquidation process actually comes to an end, there's something that will actually happen. It is actually known as dissolution of a company. Dissolution of a company. Dissolution of a company now will come at the tail end after liquidation. What will happen during dissolution? Basically, the liquidator will basically prepare a report. That report will actually be presented to where the company was registered, where its life started, at the registrar's office. At the registrar's office, a report will actually be presented there. Then what this particular registrar will actually do is basically to remove the name of the company from the register at the registrar's office. Once that has actually happened, we say the company has now actually been dissolved. So now it is actually not being recognized as actually being a person under the law. It means that even if you now do a search at the registrar's office, you won't actually be able to find this particular company in the register at the registrar's office. So at the tail end of liquidation, there is what is known as dissolution, and it is the aspect of basically the registrar removing the name of the company from the register at the registrar's office. Now it won't actually be recognized as actually being a company or actually a person under the law. It means that now the life of the company has now completely come to an end. So that is basically what will actually happen during liquidation in summary. And that is what we mean by liquidation. That is what we mean by liquidation. So what are the types of liquidation? We have two types. We have two main types. So we have what is known as compulsory liquidation, and there's what is known as voluntary. Voluntary is actually split into two. We have voluntary liquidation by members, and we have voluntary liquidation by creditors. We'll actually basically look at them and see what is the difference between the two. What is the difference between the two? Compulsory liquidation is sometimes known as liquidation by the courts. Is known as liquidation by the court. So you say maybe liquidation by the court, or sometimes you say compulsory liquidation. So those are the two main types of liquidation processes through which the company can actually be able to undergo liquidation, or how the life of the company will actually come to an end, how the life of the company will come to an end. So compulsory liquidation, just from the word compulsory, it means that the company is being forced. It's like the company is being forced that its life should actually come to an end. So this process of actually compulsory liquidation will basically start from the court. That's what you are saying. It's liquidation by the court. It's liquidation by the court. So it's basically where now a liquidator will actually be appointed by the court to basically take over the company and basically undertake the liquidation process. So that's why it is actually known as liquidation by the court or compulsory liquidation. Why is it actually compulsory liquidation? The reason why the court will appoint a liquidator is because there'll be someone who will basically petition the court or ask the court or basically give reasons to the court or maybe the high court and basically state that these are the reasons I want this company to be liquidated. And basically there are several reasons that can actually make a party or a person go to the court to state that he basically wants the life of the company to come to an end. Some of the reasons that can actually make a company to be compulsorily liquidated, is, for example, what we've just said. For example, in the scenario of Tuskys, there's actually a deadlock in management. So we have this company known as Tuskys is actually being managed by relatives who are maybe brothers, so they can't see eye to eye. It means that the affairs of the company cannot actually basically be managed appropriately. In such a case, it means that the life of the company, maybe the company will actually end up actually being mismanaged. So in case there's a deadlock in management, that could actually be a reason that can actually give someone a reason to basically go to court, give evidence as deadlock in management as the evidence he wants the court to basically now appoint a liquidator to liquidate the assets of the company. Another reason that can actually make the life of the company to come to an end is, for example, if the company is consistently making losses and there are no chances in future, this company will actually basically be profitable. It's just like what is actually happening with we don't know when it will basically start making profits. There's a famous public company known as KQ. It has consistently been making losses. I think they have made this year end of September. Is it the end of September when around 15 billion loss? So in such a case, that could be a reason that someone can actually be able to use to go to courts and give as evidence that he wants the life of the company to come to an end. So you could be asking, why is this person actually running to the court? Because he obviously knows that this particular company, maybe him as a creditor, if he basically goes to court or petitions the court, then of course he'll basically be able to realize his money from the company, because the company will basically sell off his assets during liquidation. They'll get the money to pay this particular creditor. So another question you could actually ask, is it better off to liquidate the company when it is actually at a loss of maybe 2 billion, or wait for the company to get a loss of maybe 30 billion? That's when you want the company to be liquidated. It means that if you liquidate the company when it is actually at a loss of 30 billion, then the chances of you actually basically realizing the money from the company are actually very minimal. But when you basically liquidate the company, or basically ask for the liquidation of the company when it has a loss of maybe 2 billion, it means that most of the assets of the company will basically be utilized to pay the creditors of the company, and maybe they'll get all the amounts from the company. So you're saying if the company is making losses consistently, that is another reason that a person can actually be able to use, or basically use as evidence in a court of law, or to petition the court to basically ask for the liquidation of the company. So who are the parties that can actually be able to ask for the liquidation of the company? So the parties that can actually basically go to court, we can have the parties that can actually ask for liquidation of the company. You can have creditors, you can have members of the company or a member of the company. You can have the company itself through a resolution. You can have the Attorney General. Then you can have another party we talked about here, I had already mentioned, the receiver or administrator of the company. Receiver or administrator of the company. So you've said a receiver will actually sometimes be appointed by the court. So you could go back to the court and tell them, I've tried my best in this company. What I'm just recommending is that the company should actually be liquidated. It won't come back on track. Creditors, for example, in the case of debt capital, you saw that debenture holders have a right to basically ask for the liquidation of the company or petition the court for the liquidation of the company. So creditors have a right to basically ask for the liquidation of the company. And I've told you the reason they could do that is basically they know that they will actually be able to only realize their money in case the company is actually liquidated. Like in the case of Nakumatt, receivership was not actually working. So these creditors just basically asked for the liquidation of the company. The members of the company were actually shareholders. Maybe if the company is actually being mismanaged, such that they see that they are going to lose their money in the company, that they actually invested as shareholders. So they could actually basically agree that maybe a member or maybe part of the members give good reasons to the court, such that the court gives an order or gives a liquidation order appointing a liquidator to take over the affairs of the company, or ask for the liquidation of the company. The company itself, this means that all the members have actually agreed or ask for the liquidation of the company. The company itself, this means that all the members have actually agreed, all the stakeholders have agreed that let's just liquidate this particular company or let the life of the company come to an end. They simply actually meet and pass a resolution or a special resolution that will actually basically liquidate the company. The Attorney General, mostly, for example, if it is in the case of public interest, that the life of the company should actually come to an end. Maybe the company is being involved in illegal activities. So there's a public outcry that that company is not the most appropriate company to operate in a particular society or maybe community. So the Attorney General can actually take over the matter and actually go to court, give evidence. Maybe part of the evidence could actually be complaints from that person from that particular community or actually area. If the court sees the actually genuine reasons, then of course they can give what is known as a liquidation order that will basically now appoint a liquidator to liquidate the company, to liquidate the company. A receiver, I've already told you, a receiver will basically do it in case he sees that the affairs of the company won't actually be managed, or maybe the company cannot actually be able to exist for the foreseeable future, or is not actually a going concern. So the parties that can actually basically petition or go to court with evidence stating or actually asking the court to liquidate the company compulsory are actually the creditors, members of the company itself, maybe through a resolution, Attorney General, or maybe the receiver of the company, or maybe the receiver of the company. So part of the reasons that these persons can actually be able to use, to petition the courts, we've already mentioned some of them. You are saying, for example, if there's a deadlock in management, that could actually be a reason. That could actually be a reason. So part of the reasons that can actually lead to compulsory liquidation or compulsory winding up of the company is, number one, we can actually be able to talk about in case the company passes a special resolution by the members, then where the company fails to commence business within a period of maybe 1 year after incorporation. So that could actually be a reason for compulsory liquidation, because maybe the company is dormant or actually idle. Then if the company's membership has actually reduced below the minimum requirements or statutory requirements. For example, in this case, we are talking about a public company actually having a minimum of 2 members, and there's no maximum limit. So if the company is operating with only 1 member, it means that it is not meeting the statutory requirements in terms of membership. So if the company is operating without having met the statutory requirements in terms of membership, then it can actually be compulsorily be liquidated. That could be a reason for someone to run to court and give us a reason for the company to be liquidated. We've said, for example, if the company passes a special resolution by itself, that they want the life of the company to come to an end. If the company has failed to commence business within a period of 1 year, the company is just dormant, there's no meaningful activity in the company, that could be a reason for someone to be able to use among these parties to go to court. Then we are talking about if the company is actually unable to pay its debts or honor its debts, it could be a good reason for a creditor to run to the court. The company is not meeting its obligations in terms of maybe paying interest to creditors or maybe paying suppliers. So the suppliers of Nakumat are actually complaining, we have not actually been paid our money for a very long period of time. I've made supplies for over a period of a year, I haven't been paid any amounts. So that could be a good reason that can actually make the creditor to run to court, or the court to appoint a liquidator. Then we have reasons under just and equitable reasons. So just and equitable reasons basically means that the circumstances surrounding the affairs of the company basically mean that this company is not actually a going concern, or basically won't actually exist for the foreseeable future. Basically, those particular circumstances, it means that the company cannot actually be able to operate appropriately. So under just and equitable reasons, they're the ones like the ones I've talked about: deadlock in management, making of losses consistently. We can talk about if the objective as to why the company was actually formed has actually already been met. So if the company has already actually met its objective, then of course it basically means that they can actually basically just decide that the life of the company should actually come to an end. A failure of its main objective, maybe the company is not actually able to meet its main objective as to why it was actually formed. Of course, we know the objectives of the company will actually be stated out in the articles of association. So if the company is not actually able to meet its objectives, or actually main objectives of the articles of association, then that could actually be a reason to make someone to ask for the liquidation of the company, Then we can actually be able to talk about exclusion in management. So maybe some of the directors are actually being excluded to take parts in the management of the affairs of the company. So it basically means that that could actually be a reason that can actually make the court to basically state that since these particular directors are actually excluding part of the board in taking part in the management of the company, then of course it can actually be a reason for the court to basically appoint a liquidator to liquidate, or basically to appoint a liquidator to liquidate, or basically end the life of the company, When you talk about deadlock in management, it basically means that, for example, you could be having a company that has actually only 2 directors. So 2 directors. So in this case, we can actually be talking about 2 directors who are actually maybe, we can have maybe Judy and Abby are actually directors in a company, but Judy and Abby cannot actually be able to see eye to eye. So they're the only directors and actually the only shareholders in that particular company. So because of personal reasons, they can't actually be able to see eye to eye. So wamekosana kabisa. So they can't see eye to eye. They're actually sworn enemies. So it means that how do they manage the affairs of the company? Yet they are the only two directors and that they are the only two shareholders in the company. So that could be a reason for one of them to go to court. Maybe AB can actually be able to go to court and say that I'm actually one of the directors in this particular company, but my partner, we can't actually be able to see eye to eye. There's deadlock in management of the affairs of this company of ours. So that could actually be a good reason for the court to give a liquidation order for the life of the company to come to an end. So if you can't see eye to eye, it means that you won't actually manage the affairs of the company. So that would be a good reason for the company to be liquidated. But this basically means that this company has only two members and only two directors. Let's assume, for example, if this particular company has all of us here who we are actually 10, and the directors there is actually Abby and Judy. So Abby and Judy can't actually be able to see eye to eye. So they can't actually be able to meet and manage the affairs of the company. So you can see we have only Abby and Judy. So that is actually 2 out of 10. 2 out of 10. So these two, we are actually 8. So watu wawili hawezi tuletea kichwa. Wakilete kichwa tuna point wengine wanaendelea kumanage the affairs of the company. So that scenario is most likely to happen in case only we have actually only maybe 2 members and 2 shareholders. But if we have many members, how do 2 members letea watu 8 kina? Hawa watu 8 wanaweza amua meet or pass resolution that they appoint other persons as directors of the company, So there's someone who will basically push, like Imelda convinced the others. Imelda convinces the others, is a good convincer to convince the others. Then of course it means that they can actually be able to pass a resolution to be able to appoint other persons to manage the affairs of the company. So deadlock in management is most likely to happen or arise in case we actually only have maybe 2 directors or maybe 2 shareholders in a company, 2 directors or 2 shareholders in a company, 2 directors or 2 shareholders in a company. So remember what the teacher has actually said. What is liquidation? Liquidation is that process actually undertaken to end the life of a company, whereby a person known as a liquidator is actually appointed. So what liquidation will actually basically happen then at the tail end, there will be dissolution of the company. What are the types of liquidation? The first one we've actually been able to start looking at is actually compulsory liquidation or liquidation by the courts. So liquidation by the court basically happen in case the court has actually been petitioned, been given evidence by someone, by a party. That party can actually be a creditor, can actually be a member, can actually be a company itself through a resolution, can actually be the attorney general, or it can actually be a receiver. What are the reasons that can actually make these particular parties to go to court? You've said some of the reasons could actually maybe include if the company has actually basically passed a resolution voluntarily, if the company is basically operating without meeting statutory requirements in terms of membership, if the company has actually been dormant for a period of like maybe over a year without maybe starting trading activities. We can actually basically talk about reasons under just and equitable. If, for example, if the company, there is deadlock in management, if the company is consistently making losses, if the company has actually basically maybe met the main objective, already met the objective as to why it was actually formed, if there is actually failure in the main objective, the company can't actually be able to meet the main objective as to why it was actually formed. That could actually be another reason that can actually make someone to be able to go to court, So those are some of the reasons that can actually make a party to be able to petition the court for compulsory liquidation of the company, So I think today I'm actually going to end there. So there's just remaining a small bit here. I'll actually be able to explain after these parties have actually petitioned using those reasons. When the court gives the liquidation order, what basically precedes after that, or what actually happens after that when the liquidator is actually appointed in the case of compulsory liquidation. Then we'll actually wind up with voluntary liquidation. And maybe we'll actually also be able to look at some past paper questions to wind up this particular topic, So I hope you guys were actually able to watch. There's a video I shared, a link I shared for companies. There's a link I shared for companies incorporated outside Kenya. Who has actually been able to go through it? Because that topic, I won't actually teach it again. So I don't know who was actually able to go through it. Alex, were you able to go through it? AB, I can see AB here. I can see Subo. I don't know if you guys were actually able to. I can see Alex says yes. Judy says yes, I have. And I think I had actually also, I think I went through some past paper questions. So that is what I'll actually also be able to do after the end of. So the questions here are a bit tricky. So I think we'll go through them. You see how they have actually been tested. So how they have actually been tested. Oh, Alex is reminding me about notes for reverse merger. So that one I had actually forgotten, Kabisa. But I think I'll do it tomorrow morning. I'll share it through, I think through Helen, or I'll find a way on how you'll get them. So it's good you've actually reminded me. I'd forgotten. So I think if there's no any other question, so I think we can end there for today. So that we beat this curfew. So you guys can have a good night. We'll meet next time. I think next time we'll wind up with these things. So Imelda is asking whether there is another class after this, or there is no other class for today. So there is no other class today. So this is the last class I'm having. I won't have another class after this. So maybe next time we'll have another class.